All right, so today we're going to talk about deeds of conveyance. And this is a five-part discussion. And I promise to try not to make them all very long. But we are going to specifically cover the essential requirements today for a valid deed and the critical concept of deed covenants. Now, understanding deeds is foundational to real estate law as they are literally the instrument that is going to legally transfer the ownership. So let's dig into this. So, what exactly is a deed? It is a written instrument that transfers ownership of property from a grantor, that's the person or the entity that is transferring the title, to a grantee. And that's the person or the entity that is receiving the title. So it's the physical manifestation of the transfer of legal title. So for the deed to be valid and capable of being recorded in the public records, a specific set of requirements have to be met. And these are literally their fundamental kind of building blocks when it comes to a proper conveyance. For example, a writing. It has to be in writing. And it has to state that it is the intent to convey title to the real property. This is a direct application of the statute of frauds when it comes to real estate transactions. So an oral agreement to convey land, even if it is witnessed, is not a valid deed, okay? The writing has to clearly express that intent to transfer the ownership. So, for example, if you have a handshake deal where a seller says, I'll sell you my farm for $500,000, even if the buyer says, I accept without a written deed, the transfer of that property is not legally valid, or is it recordable? Contractual powers. So the grantor has to be a person or an entity with contractual powers. That means they're competent, if an individual, and properly created if it's a legal entity. So just like with any contract, the party making the conveyance, which is the grantor, typically the seller, has to have the legal capacity to do so. So, for example, if you have a seller who is 17 years old and a deed, she signs conveying her property, this would likely be voidable by her because, again, minors generally lack full contractual capacity. But let's say that the seller is, XYZ Corp. The individual signing the deed on behalf of XYZ Corp must be an authorized officer, whether it's the president, the CEO, whatever their structure is. And they have to have the authority to bind the corporation. And it's often confirmed by the bylaws or corporate resolutions. If an unauthorized person signs, then the deed might not be valid. So the grantee must be a properly created legal entity. So if the grantee is a person, this is a little bit different because they don't have to be competent. So like a minor or somebody who has, cognitive deficiencies can still be a valid grantee. They just cannot be a valid grantor, okay? And that's an important distinction from that grantor's requirement. So while the grantor must be competent to convey, the grantee simply needs to be an identifiable legal person or entity that is capable of receiving title. So, for example, a property, again, can be deeded to a minor. It can be deeded to a trust, even if the minor or the trust beneficiaries are not competent in a contractual sense. So the law presumes acceptance of a beneficial conveyance. So like a grandparent can deed a property like directly to their 5-year-old grandchild. So while the 5-year-old cannot sign contracts, they can still legally receive title as a grantee. So let's look at the components of a valid deed. So the deed has to include words of conveyance like grant, bargain, sell, convey. You're looking for the operative words that express the grantor's clear intent to transfer the ownership. And without those, the document might merely just be an agreement or a statement and not an actual conveyance. So a deed stating seller wishes to give buyer the property, that is insufficient. It needs strong, clear words like grantor does hereby give, grant, bargain, sell, and convey unto grantee whatever the property is. The deed also has to have on its face or in an attachment to the deed, a valid legal description of the actual parcel of land. This is absolutely critical. As we talked before, the legal description has to be precise enough to uniquely identify the property being transferred. So if the legal description is vague, if it's incorrect or it's missing, then the deed is void for a lack of certainty about the actual property that's conveyed. So like a deed that only says my house on Main Street, that would be invalid. It requires that legal description, like the Lot 7, Block E, Phase 2 of Plumeria Heights subdivision, as per plat, recorded in Plat Book 17, page 128 of Cobb County, Georgia records. So the deed also has to contain the signature of the grantor. The grantee does not have to sign the deed, okay? So the grantor is the party that is giving up rights so that their signature is required to evidence their intent to convey that property. So the grantee is simply receiving the rights and doesn't need to sign. So, for example, in the sale of the property from, Sally Seller, she's, giving it, she's conveying it to Ben Buyer. So only she needs to be the one who is signing the deed. Again, he doesn't need to. Then you have delivery. The deed has to be delivered by the grantor to the grantee or it has to be a party that's acting on behalf of the grantee and accepted by the grantee. So the delivery and the acceptance are crucial for that valid transfer. So the delivery is going to signify the grantor's intent to part with control over the deed. And the acceptance is going to signify the grantee's intent to receive that title. So delivery doesn't necessarily mean physically handing over the paper. It just means that the grantor has acted in a way that shows their intent to deed, for the deed to be effective immediately. Okay. And acceptance can also be implied by the grantee's actions, like recording the deed. Okay. So let's say that you have a seller who signs the deed, places it in a drawer, intending it to give to the buyer later. If that seller dies before handing it over, there's no legal delivery and the transfer of ownership might not be complete. Now, you can probably go fight it, but that's another story. Now, if the seller hands the deed to the closing attorney with the instructions to deliver it to the buyer at closing, then that constitutes a valid delivery to the party acting on the grantee's behalf. Now, the grantor's signature on the deed has to be witnessed by at least two witnesses. Again, one of whom is an official witness, like a notary. This is a specific requirement in Georgia for deeds to be recordable. And the unofficial witness can be any disinterested party. That means they're not a party to the deed, as long as they're over 14 years old. Okay? So the official witness, the notary public, this person's job is to verify, again, the identity of the signatory and that the signature was made willingly. And this is going to add a layer of authenticity for public record keeping. So, for example, when Sally Seller decides that she wants to sign her deed, her friend, John Smith, is going to act as her unofficial witness, and a notary public is going to sign along with John Smith to attest that is in fact Sally's signature, and the notary will also put his or her seal on the document as well. So, and finally, the transfer has to be supported by good and valuable consideration. So while the deed itself often just recites a nominal consideration like $10 and other good and valuable consideration, actual consideration like the purchase price is what supports the underlying purchase and sale agreement. So the deed acknowledges that the value was exchanged. So even if it does state that it was the $10, right? Again, that nominal amount is just acknowledging that there was this underlying exchange, even if the full purchase price isn't explicitly stated on the deed itself. Now, closely related to deeds is the concept of a vesting deed. And a party's vesting deed is the deed by which the party takes title to real property. So it's the document that legally conveyed ownership to the current owner. So every past and current owner of a parcel of real property has their own vesting deed for that property. So when you're preparing a deed, it is absolutely essential to get a copy of the grantor's vesting deed. This is going to confirm how the grantor holds title and to ensure that the name used for the grantor in the new deed perfectly matches the names on their vesting deeds, trying to prevent those title defects, right? So if Sarah bought her house from Robert, from a deed or through a deed recorded in, 2010, then that 2010 deed is now Sarah's vesting deed. So when Sarah sells the house in, say, 2025, then she's going to be the grantor, and that 2010 deed is now the vesting deed that you would refer to confirm Sarah's ownership of the property, and of the proper spelling of her name. Now, let's talk about some deed covenants because these are fundamental to understanding the various types of deeds and their level of protection that they offer. So, deed covenants are promises or guarantees that are made by the grantor to the grantee in a deed regarding title to the real estate. So, these covenants provide a warranty that the grantor will protect the grantee's interest in the real property if one of the covenants fails. So, essentially, they are the grantor's assurances about the quality of the title that they're conveying. And there are traditionally 6 covenants, although not all of these promises are present in every type of deed, but the presence or absence of these deeds is what defines the type of deed. So let's break down the first 4. First, we have the covenant of season, and this covenant promises that the grantor has legal ownership of the property. It means that the grantor actually possesses the estate they are attempting to convey. So if a grantor claims to or tries to convey fee simple ownership but only owns a life estate, they would be in breach of the covenant of season. Next is the covenant of right to convey. And this covenant promises that the grantor has the right to sell the property. So while it overlaps with the covenant of season, it addresses specifically any restrictions on the grantor's ability to transfer, such as a co-owner who hasn't consented, or a trust instrument that might restrict the trustee's power to sell. So, for example, if you have a property that is owned by a corporation, but the person signing the deed on behalf of the corporation is not an authorized officer, then the corporation would be in breach of the covenant of right to convey because that person lacked the authority to be the signatory. Now, in Georgia, the covenant of season and the covenant of right to convey, they have been codified into a single covenant called the covenant of title. And that's under OCGA, I think it's 44562. And that means legally in Georgia, these 2 promises are now combined into one. Then you have the covenant of quiet enjoyment. And this covenant promises that there are no unresolved claims or issues that would interfere with the grantee's use and enjoyment of the property. So it protects the grantee from third-party claims that might interrupt their peaceful possession, such as a prior owner asserting a superior right to the land. So, for example, after a buyer receives a general warranty deed, you might have a previously unknown individual who comes forward with a legitimate claim of superior title. That would then force the buyer to defend their ownership or lose the property. So the grantor would be in breach of the covenant of quiet enjoyment if this happened. Then you have the covenant against encumbrances. And this covenant promises that there are no outstanding liens, judgments, or other matters apart from any kind of known title defects that could adversely impact the grantee's ownership. So the grantor is warranting that the property is free and clear of all encumbrances. That means mortgages, easements, unpaid taxes, all of those things, unless those encumbrances are specifically stated and accepted into the deed. So, for example, if a seller conveys a property with a general warranty deed, but maybe unbeknownst to the owner and not disclosed in the deed, there might be some sort of old unreleased judgment lien against the property. The buyer later discovers this lien. Well, the grantor would be in breach of the covenant against encumbrances. Now let's talk about the next two. So you have the covenant of further assurances. And this covenant promises that the grantor will defend the grantee's title to the real property by cooperating with the grantee's defense efforts, supplying evidence or testimony. And this is against, any and all persons. It doesn't matter in the event that the grantee's title to the property is challenged. And this is a promise of future cooperation. So if a defect in the title arises, the grantor promises to take those reasonable steps to cure it, which might mean, executing new documents. So like after closing, there might be a minor clerical error that's found in the documents, maybe like in the legal description on the recorded deed. The grantee asks the grantor to sign a corrective deed to fix the error. So under the covenant of further assurances, the grantor is obligated to cooperate and sign that corrective deed. Then you have the covenant to warrant forever. This covenant promises that the grantor will not do anything to negatively impact the grantee's title to the property once that title has transferred from the grantor to the grantee. So this is the broadest and the most important covenant, as it's the grantor's promise to defend the grantee's title against any lawful claims by any party for any reason, going back through the entire chain of title, not just up to the grantor's period of ownership. Okay? So let's say many years after conveying property through a general warranty deed, you have a remote title defect from decades ago that somehow surfaces, and it threatens the grantee's ownership. Well, the grantor is obligated to defend the grantee's title against this claim, even though the issue arose long before the grantor actually owned the property. Okay? Hopefully all this is making sense. But let's wrap this one up. We're going to quickly talk about the effect of deed covenants. So these deed covenants are going to vest in the grantee the power to pursue legal action against the grantor if any deed covenant fails. So if a promise covenant is breached, like there's a hidden lien that gets discovered or somebody else comes along with some sort of, superior title, then the grantee can sue the grantor for damages. Now, these covenants may be limited or even omitted by the type of deed that's executed, meaning signed by the grantor. And that's why the type of deed is what is important, because that is going to define the scope of the grantor's promises, which I'm going to cover that in the next lecture. But for example, if you have a grantor who, again, provides a general warranty deed and makes all 6 or all 5 in Georgia, all the covenants, offering the broadest protection, right? So a grantor who provides a quitclaim deed makes no covenants at all, offering absolutely no warranty of title, which that's what we're going to talk about. Now, I want to add one last thing, and that is that you have to remember that there are statutory time limits on bringing an action for the breach of a deed covenant. And these are the statute of limitations, which vary by state and by the specific covenants. But you'll get into that more as we kind of go through. And then if you are actually working in that area of law. Now, as we continue through the next few lectures, just remember some of these kind of key points. The differences between the various types of deeds, like the general warranty, limited warranty, and quitclaim, are again all primarily determined by the scope of the deed covenants they contain. Okay, so understanding the circumstances and which type of deed is used is going to be critical when dealing with clients. Okay, so you're not going to want a quitclaim deed for a standard residential sale, for example, because again, it offers absolutely no protection to the buyer. So a standard residential buyer will almost always demand a general warranty deed to ensure the maximum title protection. So while the transfer you might have a transfer maybe between divorcing spouses, and they might use the quitclaim if they trust each other and they just simply want to transfer the property. But you have to be aware of issues that might come up if a deed is not recorded in public records in a timely manner as well. And this relates directly to the recording statutes, which determine priority of ownership claims. So if a buyer receives a deed but doesn't record it, and the seller fraudulently sells the same property to a second buyer who does record their deed, then the second buyer might prevail depending on the state's recording statutes. But again, we'll talk more about that stuff. But just again, recognize the importance of proofreading deeds before you go and help draw them up, record them, all those things, and how to fix the errors. Because again, mistakes can be very costly and complicated to correct in this particular area of law. A simple typo, even in a legal description or the grantee's name on a deed, can create a cloud on the title. And that will require a corrective deed or an affidavit to fix later, which is going to do nothing but add, time and expense. Anyhow, that's it for this one. Let me know if you have any questions. Bye.